A brief introduction to Lanham Act competitor false advertising claims. You already know the basic, uh, strict liability regardless of intent. And then the elements are, as you see, a false or misleading factual statement in commercial advertising or promotion, materiality, deceptiveness, it's in interstate commerce, and injury or likely injury to the plaintiff results. So the fact that this fifth part is part of the test will affect things like how easy injunctive relief is to get, because even though there's now a presumption of irreparable harm, the fact that a harm requirement is part of the initial liability assessment means that that may not have as much effect as it is likely to have in, for example, trademark cases. Comparative advertising generates a lot of this litigation. There is an important subsidiary principle, just worth flagging. When you make a comparative claim, your substantiation ought to be head-to-head, unless you have a really good reason that a judge would agree with not to do it that way. So an easy example comes from a case involving Weight Watchers versus Jenny Craig. Jenny Craig advertised comparative superiority based on independent clinical trials. The TV ad showed Valerie Bertinelli in a lab coat in a lab surrounded by scientists and beakers, claiming big news, a major clinical trial run by serious lab geeks, finding that Jenny Craig clients lost on average over twice as much than the leading competitor. In fact, there was no head-to-head clinical trial. Instead, they took an interim study examining weight loss results of a group of self-help dieters using Jenny Craig and compared it to a study examining weight loss results of a group of self-help dieters using Weight Watchers. But the dieters in each group had different demographics. The Weight Watchers study was conducted over 10 years before using a Weight Watchers program that was over 4 generations old. The result was a quick injunction during the holiday season for Weight Watchers, and Weight Watchers got to go on TV saying, we've succeeded in our suit against Jenny Craig for false advertising. So that's not a great result for Jenny Craig. More broadly, we need to address head-on a core issue essentially unique to Lanham Act cases, which is implicit versus explicit falsity. This is not the First Amendment potentially misleading versus actually misleading distinction. Instead, the line is drawn between obvious or single meaning claims versus claims that potentially have multiple meanings, at least one of which is true. Ambiguity is the touchstone of an implicit message. The difference is vital in most circuits because literal falsity entitles plaintiffs to a presumption of deception, sometimes including a presumption of materiality, possibly even a presumption of injury, at least in a comparative advertising case. Without literal falsity, the plaintiff is going to have to show that consumers are actually deceived, meaning that it will almost always need an expensive consumer survey, and increasingly it will need separate evidence on materiality. Distinguishing false from misleading claims is therefore vital, and we're going to practice doing that. So first, you're going to identify the claims reasonable consumers could take away. Are there non-false alternatives in that list? If so, then a survey is likely to be required unless the court finds intent to deceive. It is very rare to base a finding of falsity on the defendant's bad intent, but it does happen. It was one ground on which the Second Circuit ruled in the Clear Blue case. Keep in mind, too, sometimes it might not be clear whether a term has a specific meaning or is just puffery, whereas other times it might not be clear which of 2 or more specific meanings consumers are likely to receive. That can affect survey practice because you might have to ask different questions to get at those different types of ambiguity. Furthermore, not all ambiguities count to make a claim merely potentially misleading. The example in the casebook is Energy 4 versus Dornier Medical Systems, a case involving claims about catastrophic failure. The court accepted expert testimony that the phrase was generally understood in the relevant medical community to mean failure resulting in serious equipment damage or patient injury. But was such testimony really a legitimate substitute for a consumer survey? And actually, that would be a good review question as you go over these materials. So this is a specific term, the plaintiff argued, with a pre-existing meaning rather than being a new claim that had to be evaluated in context. If we're going to have literal falsity at all, we need some way of determining what an ad means. At least in ads directed to subgroups of the population, it might be the case that specialized expert testimony can be appropriate. I would be I would predict less success if you argued that you could do expert testimony for a product that was directed to the average consumers in general, like a fast food ad. So that's our introduction, and I will see you in class.